The case of PELIZLOY Realty Corporation versus the Province of Benguet, having the general register number of 183137. The date it was decided on was April 10, 2013. The petitioner, Gregory K. Loy, and the respondent was the Province of Benguet, having the panate of Justice Leonen. Let's start with the facts. Petitioner, PELIZLOY Realty Corporation, or PELIZLOY, owns Palm Grove Resort, which is designed for recreation and contains facilities like swimming pools, a spa, and function halls. It is located at Asin, Angalisan, Municipality of Toba, Province of Benguet. On December 8, 2005, the Provincial Board of the Province of Benguet approved Provincial Tax Ordinance Number 052107, or otherwise known as the Benguet Revenue Code of 2005, or Tax Ordinance. Section 55 or 59, Article 10 of the Tax Ordinance levied a 10% amusement tax on gross receipts from admissions to resorts, swimming pools, bathhouses, hot springs, and tourist spots. It was PELIZLOY's position that the tax ordinance's imposition of a 10% amusement tax on gross receipts from admission fees for resort, swimming pools, bathhouses, hot springs, and tourist spots is an ultra-vires act on the part of the province of Benguet. Thus, on January 27, 2006, it filed an appeal or petition before the Secretary of Justice. PELIZLOY argued that Section 59, Article 10 of the Tax Ordinance imposed a percentage tax in violation of the limitation of the tax powers of local government units under Section 133 of the Local Government Code. On substantive ground, the Provincial Benguet, or the Province of Benguet, argued that the phrase order places of amusement in Section 140 of the LGC encompasses resorts, swimming pools, bathhouses, hot springs, and tourist spots, since Article 220 of the LGC defines amusement as pleasurable diversions and entertainment, synonymous to relaxation, avocation, pastime, or fun. Issues: whether or not provinces are authorized to impose amusement taxes on admission fees to resorts, swimming pool, bathhouses, hot springs, and tourist spots for being amusement places under local government code. The rulings: no. The power to tax is an attribute of sovereignty, and as such inherited in the state. Such, however, is not true for provinces, cities, municipalities, and barangays, as they are not sovereign. Rather, they are mere territorial and political subdivisions of the Republic of the Philippines. The rule governing the tax power of provinces, cities, municipalities, and barangays are summarized in ICARD versus City Council of Baguio. It is settled that a municipal corporation, unlike a sovereign state, is clothed with no inherent power of taxation. The charter or statute must plainly show an intent to confer that the power or the municipality cannot assume it. And the power, when granted, is to be construed in strictissimi juris. Any doubt or ambiguity arising out of the term used in granting that power must be resolved against the municipality. Inference, implication, dictations, all these have no place in the interpretation of taxing power of the municipal corporation. Therefore, the power of a province to tax is limited to the extent that power is delegated to it either by the Constitution or by statute. Section 5, Article 10 of the 1987 Constitution is clear on this point. Section 5, each local government unit shall have the power to create its own sources or revenues and levy taxes, fees, and charges, subject to guidelines and limitation of the Congress may provide, consistent with the basic policy of local autonomy. Such taxes, fees, and charges shall accrue exclusively to the local governments. Per Section 5, Article 10 of the 1987 Constitution, the power to tax is no longer vested exclusively on the Congress. Local legislative bodies are now given direct authority to levy taxes, fees, and charges. Nevertheless, such authority is subject to such guidelines and limitations as the Congress may provide. First, Section 130 provides for the following fundamental principles governing the taxing power of LGUs. Evidently, Section 140 of the LGC carves a clear exception on the general rule in Section 133. Section 140 expressly allows the imposition of the province of amusement taxes on the proprietors, lessees, and operators of theaters, cinemas, concert halls, circuses, boxing stadiums, and other places of amusement. However, the resorts, swimming pools, bathhouses, hot springs, and tourist spots are not among these places expressly mentioned Section 140 of the LGC as being subject to amusement tax.